Hello and welcome to the Indiana Lawyer Podcast, your source for news and Hoosier Law, brought to you by Taft. I'm Alexa Shrake, Indiana Lawyer Reporter, and your host this week. I'm here in our Monument Circle studio with Derrick Mason, Executive Director at the Indiana Public Defender Commission. Derrick has been the Executive Director of the Commission since March 2022 and was a senior staff attorney for 7 years before being promoted to Director and Chief Counsel in July 2021. So to start, Derrick, can you explain to us a little bit about your role leading the Indiana Public Defender Commission?
Yeah, so the Indiana Public Defender Commission is now actually the Commission on Court-Appointed Attorneys as of July 1st. So new change for us. And it was still same entity, just a new name to help differentiate ourselves from the other public defender entities that do exist at the state level. It gets confusing for people. So we thought we'd try to take the word public defender out of our name so that we don't match up with the other two that exist. But ultimately, I've been with the commission since 2014. It used to exist under the Indiana Supreme Court before it was farmed out to be on its own. So we are an independent judicial branch agency. And that's been quite the time to be able to go and, like I say, be under the Supreme Court's auspices to independence, advocating for our own budgets, going before the legislators and directly advocating for what we feel public defense needs in Indiana has been great. That has been something that we've been doing since we became independent in 2016. And one of the things that we do involves our misdemeanor reimbursement that we've been trying to get for over 20 years. When the commission first started, we actually reimbursed counties 25% of all of their public defense expenses, both misdemeanor and adult felony and juvenile delinquency, I should say, those cases and appeals of those cases. But not enough counties I would say, were interested in receiving reimbursement for 25%. And so it was really a financial decision. How do we get counties more interested in participating in commission standards in order to receive reimbursement and without having the state spend a lot more money? And at the time, it was to raise the reimbursement rate to 40%. And in exchange for that 40% reimbursement, we only reimbursed adult felonies and juvenile delinquency cases at those times. So we cut out misdemeanors as the most common case type, but the least expensive case type typically as well. So counties started to increase participation. One of my main goals is to continue to increase participation as executive director. And we are now to 68 counties that do receive reimbursement from the commission in exchange for their participation and following our standards and guidelines that we set on non-capital cases. All counties are eligible for reimbursement of 50% for their death penalty expenses if they follow the Supreme Court's Criminal Rule 6 now, because it's been renumbered to number 6 for death penalty cases. But ultimately, our number one goal is to provide full 40% reimbursement for all case types where public defenders are regularly and routinely appointed. And then in exchange for that, have those counties participate in our standards and guidelines, which we have done numerous studies on to show improves not only outcomes, but lowers jail populations and a wide variety of other benefits that come along with participation in those standards.
And, you announced last month the new misdemeanor pilot program. So can you kind of tell us what that's going to look like?
Yeah, so we're very excited about it. Just was authorized this last legislative session. So the pilot does not actually start under the current statute that's allowing us to pilot that until July 1st of 2025. And our main goal with that pilot is to be able to collect data on both counties that are in compliance with our misdemeanor standards and counties that are not. And hopefully we also have counties that are not at the beginning of that pilot. And then they switch to compliance during the length of our pilot. And during that time, we can hopefully measure the differences in outcomes for those people that are charged with misdemeanors and be able to provide back to the legislature, yes, we should be able to fund misdemeanors at 40% because there is a benefit to counties, to the state, to our citizens. Ultimately, that's our goal, is to be able to find out actually through this misdemeanor reimbursement program, or pilot program, I should say, to be able to show what are the impacts of that reimbursement and following standards.
And so where did the idea for this program come from?
Yeah, it's been a long time kind of percolating where we've been, again, advocating for over 20 years to return misdemeanor reimbursement authority to the commission because we did have it, right, at 25%. And so now that we're at 40% reimbursement, we have 68 counties. Well, we operate in what's called a misdemeanor loophole, right? And so if an attorney in one of our 68 counties only receives non-reimbursable cases, aka misdemeanors primarily. If they just take misdemeanors, then they don't have to abide by any standards. They can have over 1,000 cases a year, in which case that was happening. We've been able to work and get that down a little bit. So I don't think we currently have any attorneys that we know of that have over 1,000, but we have some that have several hundred. And as any attorney would know, representing several hundred people in a year on different cases. And that is could include one misdemeanor that has 12 counts, right? It would count as one misdemeanor for our purposes. So there could be a lot going on in one case, and it can be quite challenging. It's impossible for many attorneys to be able to really dig in and do investigation and do all the things that, you should be doing in every case when you are representing someone charged with a crime. I say impossible. It's not guaranteed impossible, right? There are some attorneys that do an excellent job, with high caseloads. But at the same time, we know that participation in our standards and all the other case types improves outcomes. It's going to be hard for me to believe that lowering caseloads to a somewhat reasonable level, or hopefully a somewhat manageable level, it would be hard for me to believe that wouldn't make an impact on people. And so our goal ultimately is, how do we show the legislature this information? We've been advocating it for a long time. We can show them outcomes in other case types, but we haven't been able to swing them over to full reimbursement. And so when we went to the legislature this last session, we're like, well, what if we just piloted this? And originally it started with some named counties, and then it became, this legislator wanted their county and this legislator wanted their county. And there were a bunch of counties saying, what about us, right? And so ultimately, instead of named counties, they are allowing us to do 12 counties that we select. And then the statute just dictates that we have to prioritize geographic diversity and population diversity. And then obviously we are interested in their ability to collect and report accurate data, because that's super important. The whole goal of this is to collect this data, right? And to be able to show what kind of impact misdemeanor reimbursement may or may not have in different areas. I'm not going to say every area is going to be impacted, but it'd be, again, hard to believe that won't be something impacted. And so our goal ultimately is to find those counties that are both in compliance with misdemeanors right now voluntarily. They don't operate in that misdemeanor loophole with their attorneys, and also counties that do and that are willing to possibly transition to compliance during the life of this pilot, so we can measure kind of a before and after. As well as, we're interested separately just from this, we've also extended the idea that we will help fund just data collection agreements, so that if a county wants to just collect the data, or they're willing to do the collection of the data regarding their existing program, even without the reimbursement, because we are limited to 12 counties to receive up to 40% of their misdemeanor expenses. We could have more than that participating just in the data collection portion without the misdemeanor reimbursement, because we do studies on public defense all the time, but legally we're not allowed to provide misdemeanor reimbursement, except for soon to those 12 counties.
And I saw, people get to apply for that.
Yeah.
How has that been so far? What kind of feedback are you seeing? Have you received a lot of applications?
So I appreciate the timeliness of this so that we can continue to get word out. So we just launched the application really last week, so the end of the month. And we've been telling counties that we're prepping this, right? But we unfortunately are still a little behind the eight ball, because part of that statute requires, in addition to this data collection component, requires a trickier component. And participation requires that every court in a county that receives misdemeanor money as part of this pilot, every court that regularly makes indigency determinations to appoint counsel must actually use a form that is developed by the Office of Court Services. And they have not yet developed that form. They're working on it. They've gotten notice since, July 1st when this, this whole law became effective. But ultimately, they're working on that form. And so it's hard for a county to say, we will comply, right, with whatever this form says and ask these questions and do the verification that's required under the statute. it's hard for them to say that when they don't know what that is. So we're not soliciting exact applications that say, I will do all of these things. And we're not sending out grant agreements and things like that hold people to the fire. What we're doing right now is saying, here's the requirements, including this. Talk to your courts. Do they seem willing to do these things? Is everyone in the county willing to do the data collection that's required? Is everyone willing to do a form of some kind? And then once that form is released, which will hopefully be by the end of the year, beginning of next year, we can actually start finalizing our participants. So we'll try to prioritize our participants in order of who we would like. And then once we have that form, get back with them. And if they say they're not going to participate for whatever reason, we can move on to the next counties down the list till we hit our number of up to 12. Obviously, we have to take into account our own fiscal resources. We can't take 12 Marion counties, and be able to do this, because also by statute, we have to use our existing resources to fund this. We don't get additional general fund dollars to be able to do this misdemeanor pilot. We said that we do believe we have the funds to run this pilot, and so we are doing it on our existing funds. We do have some additional funds coming in from public defense user fees that are being assessed as of July 1st. From every county should be assessing those fees on every case, except on every adult felony or misdemeanor case, unless they find that person to be so indigent that they cannot afford any of those fees, which is totally fine. But most people could probably afford a $100 or $200 fee that would be paid over the course of any probationary term or out of a bond or whatever. But that's ultimately up to the courts to decide if they assess those fees and how. And we don't yet know how much money that will generate for us either. So we'll see. It's not going to be we're certainly not funding the misdemeanor pilot off those funds. It's off our existing funds, but we do have some additional small level of revenue stream coming in.
And when are the applications due?
So we've had a lot of verbal interest since the law passed, and we've had just a couple in the last week even submit actual applications, which is great. We are receiving them kind of on a rolling basis. I feel like I used to work at the Office of Admissions at Indiana University. We accept applications on a rolling basis. Our priority date is, things like that. So our priority date really is just December 6th, and that's because we have a commission meeting. If we need the commission, we meet quarterly. If we need the commission to approve certain counties or approve anything, we want to be able to do that and get funds rolling because we want to start data collection as soon as possible, right? We want that before and after reimbursement time period. And that, again, is not providing any misdemeanor reimbursement. It's just data collection. And it's a small amount of money, but it's an agreement that we need from the counties to start doing it, that are willing to do it. And so we're trying to identify those counties immediately. And so any county that wants to participate in this, we're asking them, are you willing to participate in the data, even if you're not selected? So we can start getting those data agreements in place. So December 6th is our ideal priority date, but we are going to continue receiving applications until we have finalized all up to 12 participating counties. And I keep saying we would love to have 12 counties. That's what we're allowed to do. But it'll depend a lot on the financial resources that each county would be requesting for their reimbursement. Obviously, we will not be able, like I said, to take 12 Marion counties. And so it's just a matter of which counties actually apply and how much money it would end up costing for that reimbursement over the length of this pilot, which is from July 1st, 2025 to June 30th, the end of the state fiscal year 2029. So it is a 4-year pilot program.
When I first saw that date, I was like, that's so long. That's so far away. And now when you said 4 years, that's
I know,
not actually
right?
that far
Well,
away.
because it doesn't start yet even till 25, the middle of it, right? It is a nice lengthy pilot. And what we want to reiterate to counties is that we aren't expecting you to come in compliance in the middle of a county budget year on July 1st. Magically, you're just, that's not the goal. The goal is to say, hey, we're not in compliance, but we have a plan to get into compliance during the life of this, and we're going to collect all that data in the meantime. That's totally okay. We don't want all compliant counties participating, because then receiving the reimbursement isn't necessarily going to make that big of a difference on outcomes unless they're using that reimbursement to enhance their public defense system, which would be a great application selling point as well, right? Because even if they're in compliance, but they're going to take this reimbursement, not just pocket it in the county coffers, but reinvest it in some way, that could actually show positive outcomes and misdemeanors that they didn't previously have anyway, and other case types. So I'd be totally happy to receive applications from participating counties that have something novel like that, I would say that would put them ahead of just a regular old participating county that just wants the money. I would like to think it would.
So is there anything else that, you want to add about this that I didn't think to ask you, or just that the commission is working on?
Yeah, I appreciate the opportunity to speak about the commission in general and the misdemeanor pilot, kind of get word out there. So if you're an attorney listening, go back to your county and say, one, why are we not participating in the commission's reimbursement? If you're one of the other counties of the 92, that's not the 68 participating counties, why are we not getting 40% of this entire fund back? Because before we started, you and I briefly talked about the attorney shortage, right? And counties are facing increasing costs. They're facing, to get attorneys interested to do public defense, they have to pay more, right? And so misdemeanor reimbursement can help offset those costs for counties. So that's important. But in general, the 40% reimbursement, now we reimburse juvenile delinquency, adult felony, children in need of services, termination of parental rights cases, CHINS cases, those things. And then appeals of all of those case types and mental health commitment hearings and appeals of those are all 40% reimbursable. So the vast majority of case types, I will say, obviously just not misdemeanors and some contempt proceedings and things like that we don't yet reimburse for. So if you're an attorney listening, ask that question first. And second is, hey, even if we're not in the misdemeanor loophole county, right? Everybody's in compliance. Things are going great. How we should apply, let us know. Work on your chief public defenders if you happen to have one. Work on your public defender board that is supposed to exist pretty much in almost every county. If you're a super small county that does not have a public defender board, then you can go to your judge. Because that's typically who runs the program. If they're a less than 12,000 county population, then the judge typically runs the public defense program. By statute, they're allowed to do so, and receive reimbursement. And so, go to them and go to your judges and have them put pressure on county officials about receiving this 40% misdemeanor pilot, even if you are receiving 40% of everything else. So it really requires a groundswell of people to say, we want change in this county. We need to make more money. All our attorneys are retiring. I have a lot of counties that are creating chief public defender positions right now. And that's it, not an office, just a chief public defender, because it's a recruitment tool. Even if it's a part-time chief, right now I can recruit someone, pay them a part-time chief public defender salary, get 40% of that back from the state. And then they can do part-time work in my community because all of my attorneys are retiring out. I don't have many people left to pick up that caseload. So you can start adding attorneys to your community through strategic use of these funds. So there's a lot of different opportunities and options, and I encourage people to reach out to us. Our website's just in.gov/public defender or /CCAA for our new name, Commission on Court Appointed Attorneys. Both of those websites will get you to us, and they can find my email address on there. It's derrick.mason@ccaa.in.gov. Feel free to give us a call. We are here to help recruit counties. It's our number one priority, is to make sure that we have adequate funding from the state every year to provide our promised reimbursement, and to get more counties to participate in the standards and guidelines for public defense. So anything we can do to help you get there, we're happy to do it.
This is always on my mind, just because of my background, but gotta ask, we have a legislative session coming up, and it's a budget year.
Yeah.
Is there anything that the commission is looking at and asking for more funding,
right,
or just any other new programs?
So interestingly enough, we've been asked to speak November 12th at the initial budget hearings for the judicial branch in front of the legislature. And so we don't have a lot to say at it because we are not requesting any additional funding. We knew it's been a battle to get misdemeanor funding this whole time, right? To return it. It's not something novel. We did provide it before, but at the same time, to convince people that it's worth doing. And, I think everybody acknowledges that our public defender reimbursement program is a solid program. It's been around since 1989, and it's been very effective in many ways in improving public defense. But convincing them to do the misdemeanors is its own unique challenge. It is the most common case type in the state of Indiana. So even though it is typically one of the least expensive cases, there's a high volume of them. So when you're considering all of that, we really pushed for this misdemeanor pilot and said, let's just test the waters and see how it goes, right? But in exchange for that, we told them, again, we would use our existing funds And so we didn't want to come back and say, give us more money. I did advise everyone at the legislature that I spoke with that we could need more money in the future if more counties join. For example, we just had White County join as our most recent county, but we can sustain for one biennium. We believe we can sustain most counties that would join for the 40% reimbursement program, because most of your biggest counties are already part of the program. Mainly the biggest counties that aren't are surrounding a couple surrounding Indianapolis that are relatively large that don't participate, such as Johnson County and Hamilton County. Do not receive the funds, although there is some increase in interest in Hamilton County to possibly do that. So we're happy to continue to engage with them. But ultimately, as long as, again, we don't have a massive increase in participation during this 2-year period, we believe we'll be all right. But in the next biennium, I think it's totally reasonable that we would be going back and asking for specific funds just based upon the amount of increased expenses our counties are seeing and increased participation, but not, again, related to the misdemeanor program.
Well, I think that does it for this interview.
Sure.
Derrick, thank you again for joining me today. To our listeners, stick around after our sponsor break to hear this week's headlines.
Taft, today's modern law firm. At Taft, we cultivate a highly respectful, transparent workplace that fosters creativity, teamwork, inclusion, and diversity. We couple our culture with a client-first approach, rewarding lawyers who understand their clients' goals and work to deliver success. Taft, the modern law firm. To learn more, visit taftlaw.com.
Welcome back. Managing Editor Daniel Carson and reporter Maura Johnson and I are here to give you the rundown on the latest legal news. So let's get started. Today is Wednesday, November 13th, 2024, and these are your headlines. Maura, you have news about a new IndyGo lawsuit. What can you tell us?
IndyGo's Transportation Corporation is suing over $4.7 million in construction cost overruns for the Julia M. Carson Transit Center that it claims were caused by an infrastructure consultant's failure to properly investigate the construction site for potential complications. The Indianapolis Public Transportation Corporation filed a lawsuit on October 25th in Marion County Superior Court against Dallas-based ACOM USA Incorporated, which has an office in Indianapolis, and the URS Corporation. Legal representatives for ACOM could not immediately be reached for comment. According to the lawsuit, the Transportation Corporation entered into an agreement with URS in April 2013, and URS was later acquired by ACOM, which was assigned to serve as lead designer for the construction of the Julia M. Carson Transit Center at 201 East Washington Street. As lead designer, ACOM led the development of the transit center's design, which included being responsible for investigating potentially unsuitable soil on the design site, IndyGo said. The company's design for the transit center was finalized in July 2014, at which point IndyGo awarded a construction contract to Weddle Brothers Building Group, LLC. That November, Weddle began archaeological monitoring of the construction site and almost immediately found unsuitable soils in the footprint of the proposed building area, according to the lawsuit. Weddle also discovered numerous structures like brick and foundation wall remnants on the site, preventing them from continuing their work. Because of the conditions of the building site, construction of the transit center was delayed, requiring more compensation and deadline rescheduling for Weddle, the lawsuit claims. IndyGo says that for over a year, ACOM led the transportation company to believe that the soil on the building site was appropriate for construction. In addition, IndyGo claims ACOM didn't inform it that a full data recovery level archaeological report would have to be prepared for the Federal Transit Administration, which largely funds and regulates IndyGo, until after ACOM finalized its design, also leading to additional costs. According to the contract between IndyGo and ACOM, the project was supposed to be substantially completed by October 2015, but didn't reach that stage until June 2016. IndyGo says it incurred costs overruns in excess of $4.7 million as a result of ACOM's actions and failures. IndyGo is suing for breach of contract, breach of express contractual warranties, and breach of warranty of the adequacy of the plans and specifications. It is seeking damages, quote, in an amount to be determined.
Thanks, Maura. Next, Daniel, you also have news on a lawsuit. Tell us about this dispute between churches.
A small New York City church has sued Indianapolis-based Disciples Church Extension Fund after the nonprofit lender allegedly declined to release $7.3 million in loan funding advances for a proposed development on the church's property near Central Park. La Hermosa Christian Church filed the lawsuit in June in the New York Supreme Court's New York County Commercial Division. The Extension Fund, which is the financing arm of the Indianapolis-based Christian Church Disciples of Christ denomination, denies the lawsuit's allegations. The lawsuit alleges the Extension Fund defaulted under the parties' loan agreement by failing to make advances requested by La Hermosa in November and December 2023 and January 2024. The complaint claims the Extension Fund promised to advance funds to La Hermosa to finance the pre-construction phase of a construction project that would develop its property with a high-rise building that would offer housing, a new church, and new local community facilities. Disciples Church Extension Fund Vice President Reverend Rhonda Hopewell said in an emailed statement that her organization fully denies the allegations. Quote, Disciples Church Extension Fund has been a partner with La Hermosa Christian Church and supported their ministry for many years. DCEF's role has been as a pre-development lender, Hopewell said in the email. While we fully deny the allegations in the case, it is our sincere hope that the church can find a development partner to help them accomplish their desired project in the meantime. DCEF has a responsibility to be good stewards of the funds entrusted to us from our investors, donors, and partners, end quote. Samuel Levy, an attorney with New York-based Blank Rome LLP, who is representing La Hermosa, told Indiana Lawyer in an email that as a policy, his firm does not comment on active litigation matters. The Extension Fund filed a motion in August to dismiss the case. In that motion, the organization asserted that it had supported the New York Church's dream, as evidenced by its provision of a pre-development loan and advancing more than $11 million to the church for the project. Quote, this project, however, has lost its focus through no fault of DCEF, a nonprofit lender to churches which offers extremely generous terms, the dismissal motion alleged. The Extension Fund argued that La Hermosa still has no firm prospects with the developer to develop the property, with no financial institution going to make an approximately $300 million construction loan to a small church with no endowment that lacks a credible financial development partner. La Hermosa is suing for breach of contract, breach of an implied covenant of good faith and fair dealing, and for a declaratory judgment, as well as lawsuit expenses.
Thanks, Daniel. The Indiana Court of Appeals reinstated Olympian Talia Brooks' amended lawsuit against USA Track and Field, reversing a lower court's decision. Brooks filed her lawsuit against USA Track and Field after suffering heat-related injuries while competing in the 2021 U.S. Olympic heptathlon trials in Eugene, Oregon. While the ruling allows Brooks' injury claims to move forward, it upholds the waiver, release of liability, assumption of risk, and indemnity agreement that track athletes must sign to participate in sanctioned competitions. The court notes that while the indemnity agreement protects USA Track and Field from negligence claims, it does not grant the same protections for gross negligence. Consequently, Brooks can move forward with any claims of gross negligence. Brooks' counsel argued before the state appellate court in August that USA Track and Field could have prevented Brooks' injuries by moving the event later in the day to take advantage of cooler temperatures, as it has done for other events. The appeals court sent the case back to Marion Superior Court for further proceedings, and it noted that if USA Track and Field has challenges to Brooks' injury claims, then it can raise them with a motion for summary judgment or other motions. Since 2021, Brooks has continued her track and field career, qualifying for the 2024 Summer Olympics in Paris, finishing in 11th place overall in the heptathlon. Going back to Daniel, who has news on an order for an Indianapolis business to stop preparing tax returns.
An Indianapolis area tax return preparer is out of business after a federal investigation into his activities revealed an alleged recurring pattern of fraudulent tax preparation practices. Chief Judge Tanya Walton Pratt issued an order for Juan Santiago, owner and operator of Madison Solutions LLC in Indianapolis, that permanently enjoins him from preparing federal tax returns for others and from owning or operating any tax return preparation businesses in the future. The IRS estimated that Santiago's fraudulent tax preparation activities had caused about $1.3 million in tax harm to the United States Treasury each year. Indiana lawyer attempted to reach Santiago but was unable to leave a message at the Madison Solutions LLC phone number listed online. According to the civil complaint filed in the case, Santiago resides in Lakeland, Florida, but travels to Indianapolis for tax preparation season to operate his tax preparation business. Santiago failed to respond to the civil complaint filed against him, so the court entered the permanent injunction against him by default. He also refused to cooperate with the IRS in its investigation. The civil complaint alleges that Santiago and Madison Solutions used a variety of schemes to improperly reduce their customers' tax liabilities or to obtain tax refunds to which the customers were not entitled. The complaint alleges that Santiago repeatedly placed false or incorrect items, deductions, exemptions, or statuses on customers' tax returns without their knowledge. The complaint alleged many of Santiago's and Madison Solutions customers are non-English speaking immigrants from Mexico. During 2020, 2021, and 2022, Santiago and Madison Solutions prepared an average of 1,026 returns per year.
Thanks, Daniel. The Marion County Judicial Selection Committee has announced 6 finalists for 2 upcoming vacancies on the Superior Court bench. The committee interviewed 27 candidates on October 28th and 29th to succeed Marion Superior Court judges John Hanley and Mark Stoner, who are retiring at the end of this year. The finalists for one vacancy are Lawrence Township Small Claims Court Judge Kimberly Bacon, Magistrate Judges Tara Melton and Terrence Tharp. Finalists for the second vacancy are Magistrate Judges Pauline Beeson, Catherine Melnick-Celine, and James Snyder. Once Governor Eric Holcomb officially receives the list of finalists, he will have 60 days to name the 2 new judges. Moving on to election news, Maura, what do you have to start us off?
A Republican precinct committeeman was arrested in Madison County and charged with stealing ballots from a ballot card voting system during a public testing of the machines. Larry Savage turned himself in on October 29th at the Madison County Jail following a warrant for his arrest. Savage is a former Republican primary candidate for the 5th District. He was charged with theft, a Class A misdemeanor, and destroying or misplacing a ballot, a Level 6 felony. Indiana lawyer could not immediately reach Savage for comment, but he told Fox 59 that at no time did he actually think the ballots were real. He told the television station, quote, "I didn't mean to hurt anybody, and if I did, I'm sorry. I'm just trying to fight for our country. The truth is going to come out, and I am an innocent man," end quote. According to the Indiana State Police, staff at the Madison County Government Center were running the voting system technical oversight program, which tests election equipment in the state, when they discovered, after an initial tabulation, that 2 ballots were missing from the same machine. These equipment tests are done in front of representatives of political parties, candidates, the media, and the public. Savage was a member of the public who was attending the testing that day. During the program, a pre-audited group of ballots are manually entered to test the system's effectiveness. After the testing process, the ballots are treated as if they were used on Election Day. When staff discovered 2 ballots were missing, police were able to narrow down their search for the ballots using surveillance footage, which showed Savage putting the ballots in his pocket, authorities said. Savage was present to receive instructions about the test and therefore knew the ballots were not simply sample ballots, according to court records. He reportedly told another individual at the test, quote, "They're absolutely totally real ballots, except they say test on the back of them," end quote. Text messages from Savage's phone revealed He talked to the same individual about the stolen ballots, asking, quote, "Sis, they say anything about the ballots I took?" End quote, to which the individual said no. Authorities searched Savage's residence and reportedly found the missing ballots in his vehicle. An October 17th post made by Savage on Facebook shows his continued attempts to justify his actions in taking the ballots and/or instill doubt about the integrity of the election, court records state. Madison County Prosecutor Rodney Cummings said Savage's arrest will hold him accountable for his alleged behavior and let the community know that his allegations that the election is fraudulent are not accurate.
In the November 5th election, Republican incumbent Todd Rokita secured a second term as an Indiana Attorney General. Rokita claimed 60% of the vote compared to his Democratic challenger, Destiny Wells, who saw 40%. At the state Republican Watch Party on election night, Rokita credited his victory to rejection of, quote, the push to the left, end quote. Rokita told supporters Tuesday night that he would continue to put criminals behind bars and, quote, ensure boys do not compete in girls' sports, end quote. Quote, because of your great General Assembly, we were able to make sure that those surgeries on minors, those transgender surgeries, are stopped and prohibited, Rokita said. They need therapy. They don't need child abuse, end quote. While Attorney General, Rokita has attained a 94% success rate in keeping criminals behind bars and collected a record $1 billion from corporate wrongdoers over 3 years. He was first elected to public office as Indiana Secretary of State in 2002 and served 2 terms. He then was elected to the U.S. House of Representatives, where he served for 8 years. Then he lost the GOP primary for U.S. Senate to Governor-elect Mike Braun in 2018. Rokita was elected as the state's chief legal officer in 2020 after beating incumbent Curtis Hill for the Republican nomination. The election also saw all 3 Indiana Supreme Court justices on the ballot win a retention vote, along with 2 Indiana Supreme Court appeals judges. Chief Justice Loretta Rush, Justices Mark Massa and Derrick Moulter, and Judges Rudolph Pyle and Peter Foley will remain on the bench for another 10-year term. And finally, to wrap up this week's headlines, Maura, tell us what you are working on for our next print edition.
For our next print issue, I'll have a story on how lawyers on Governor-elect Mike Braun's transition team are working to ensure his move into the office is seamless. You'll hear from members of his team on how they're preparing for a new administration to take office and who will be filling what roles to support the soon-to-be governor. You can read the full story in our November 20th print edition.
Okay, that'll do for this week's headlines. As always, if you want more legal news, check us out at theindianalawyer.com.